Greetings. I hope you guys are all having a pretty good day. And it's time for the American people, and furthermore the people of the world, to wake up to what is truly transpiring and affecting their offspring, their grandparents. You see people having estate sales because their granddad or whatever is in a nursing home, and the state comes in and says, well, we're taking care of your granddad, and so we're going to sell off all his properties. We're going to make sure that he has nothing to leave to his family. Everything he's worked so hard for will be gifted to the state, because now allegedly the state, quote unquote, is taking care of your granddad. This stuff has to stop, people. The reason your generations are not prospering is because the state is stealing from you, and you just don't realize it. You think it's just a way of life. It's acceptable. It's just common knowledge, Derek, that when somebody goes to a nursing home, the state comes in and forces the person in the nursing home to sell everything they've ever earned in their life, which is absolute asinine. Because of the way that the monetary system is set up, all one simply would have to do is create a private bill of exchange or a bond and put it into the market in order to take care of themselves in a nursing home situation. But enough about that. Let's get on to some real remedies of sort. What are your claims and defenses? Under the UCC 3-305, you have a claim in recoupment, ladies and gentlemen, which is a counterclaim. And that is the same language in Rule 13 of FRCVP, and I believe it's supposed to be FRCP. Rule 13 says that there are two types of counterclaims. There is a mandatory and a permissive counterclaim. Mandatory arises from the same transaction and occurrence as the plaintiff's claim, and no one is filing a counterclaim. That is why they are running over you. You can't be a creditor unless you file a counterclaim. UCC 3-305, second claim is a UCC 3-306. Go look them up. You have a proprietary and possessionary interest in the note and its proceeds. You have the right to rescind negotiation of the transaction. Negotiation means the endorsement on the note. They also endorse these notes, paid to the order of. You have a right to rescind that negotiation. No one ever does it because they don't read the UCC. If they are non-negotiable, they are not governed by Article 3. They're governed by general contract law, specifically Restatement of Law, second series under contract section 164, which has to do with misrepresentation, which means it's subject to rescission. If you read 226.23 of the TILA or Reg Z 12 CFR in the appendix, there is a form H8 and H9. It is in the appendix. Now, H8 and H9 is a way, it's something the bank didn't disclose to you. It's a way that you can get all your FRNs, your sweat equity notes, as I like to call them, back. And because they didn't disclose this to you, you still have the right to rescind your signature under the TILA laws, TILA, for failure to disclose. And so now that you're aware of this fact, you can go in and find the H8 and the H9 form, which they have hidden from you, and recoup everything. So if they're going to foreclose on you and they're going to steal your property anyway, go get your sweat equity notes back, file the H8 and the H9, and it is mandated that they must provide your FRNs back to you, your credits on account. And that's just a little bit of knowledge for you there, ladies and gentlemen. It doesn't even for me, it doesn't even come close to the main issue. But if all else fails, at least get your sweat equity notes back for everything that you've paid in. File the claim. If you read 8-505 to 8-508, it tells you how to file the claim. Okay, that's the UCC 8-505 to 8-508. It tells you how to file the claim. The counterclaim is called an adverse claim. It defines in 8102 and 8105 of Article 8. Remember, ladies and gentlemen, everything is done through the UCC, Uniform Commercial Contracts. There are two issues, an investment contract and a tax. The reason a tax comes into play is because they never transferred the security. They kept the security. So that means all the investors that bought cash flow claims under the pooling and servicing agreement have got worthless paper. That means there is a cloud on every title, and none of these notes were ever securitized. That means every B5 prospectus, S3 registration statements, and 8K current reports are all invalid that are filed with the SEC because the notes, the security, were never transferred at closing. In response to the lady that asked about the 1099 OID, all these people that are filing the 1099 OIDs and 1096s and 1040s and 1040Vs, they are not filing the 8281, which is mandated when you file any of these documents. An 8281 identifies who as the issuer of the OID is under Title 15, Section 78, CA8. Go read it. It identifies you as the issuer. Because you did not identify yourself as the issuer, you don't have a claim. IRS Publication 1212 is extraordinarily important, ladies and gentlemen. IRS Publication 1212, page 2, that you must file an 8281 when you file the OID. You must read publication 1212. That is what you need to file as the issuer. Read also 1271 to 1288 of Title 26. Everything is an OID. Why? Because it is a public debt instrument, period. Everything is a public debt instrument, okay? The office is vacant. As a donor, you have the power of Appointment Act of 1951. You can appoint yourself as executor, put in letter under 2038 and 2514 under Title 26. I'm appointing myself the special occupant of the legal estate of the decedent by absolute estate. As the donor beneficiary of this constructive trust, I am appointing myself. I am claiming the office of the special occupant of the legal estate. It is not a legal estate because there is no executor or executor. Go in and say when you're in a court, and you want to come in proper, you're going to start out by, I am here by special appearance upon proof of claim. There are only two ways of staying in honor. One is just to outright pay the debt. The second one is to do a conditional acceptance, ladies and gentlemen. Okay? And we're going to do a special, we're going to appear by special appearance. As I've stated before, only ghosts appear. So we're going to do a special appearance upon proof of claim. I will conditionally accept your offer on the proof. This is a court of record, and this is a land court that has jurisdiction and venue under the Constitution to litigate land cases. I'm going to say that again. Go into the court and say, I am here by special appearance upon proof of claim. I will conditionally accept your offer on proof. This is a court of record, and this is a land court that has jurisdiction, both in personam, okay, and subject matter jurisdiction, and venue under the Constitution to litigate land cases. Title 26, that is, send them a letter that under 2038 and 2514 under Title 26, under the Power of Appointment Act of 1951, you are appointing them as the executor of the estate of the decedent, and that makes them liable for all taxes on the estate. The executor has to pay the tax. You could appoint the judge, the executor. They will run out of the courtroom. The IRS, this is an actual IR manual It is 5.5.4.1. It talks about Form 10,492, Notice of Fed Tax Due Under 31. USC 3713. Read the Uniform Trust Code. Sections 406 or 407 tells you how to form a trust. You can do it orally, ladies and gentlemen. You have the Power of Appointment Act of 1951 under Section 2038 and 2514 of Title 26 as the donor and beneficiary of the record. You are appointing the judge the executor of the legal estate of the decedent. Ask him if he brought his track shoes, because he's going to burn up that floor trying to get away from you. He wants no business with that tax liability. You don't want it. He's going to get pissed. He might even threaten contempt of court. At that point, you just smile. Hi, how are you? Glad to do business with you. So happy you wanted to be a public trustee and a servant unto me. Read IRS Manual 5.5.1 and 5.5.4.1. Proof of claim procedures and non-bankruptcy insolvent cases. Insolvency is a dead person. Read 3128 and 3113 of Title 31. When a person has proof, they can draw on the payment. A complete claim will have your certificate of protest and all the supporting documents, i.e. original affidavits, your original certificate of service of original presentment, your notary presentment letter, if applicable, notice of default, certificate of service of the notice of default, along with certified copies of your return receipt, Postal Service Form 3811, and Reg Mail Receipt 3806. Okay, that's Registered Mail Receipt 3806. And then I would slap an apostille on top of it, or certification from the Secretary of State making it self-authenticated claim, a self-authenticating claim. You have a third-party witness to every element of the claim, which is essentially a judgment. Now, where do we find this third-party witness, ladies and gentlemen? We are using the United States Postal Service as our witness. And not only are they our witness, but they are a federal witness, which is absolutely beautiful, all right? In Title V, Am Juris Prudence, in Title V, that's what they are doing to you. It's not the bank. It's not that the bank has any claim on your house. It's that they get you involved in a commercial process where you default on the process. That's how they establish the claim. Every time you receive something in the mail, it's a new offer. A new claim is being established. Ladies and gentlemen, do not disregard the things that are coming in the mail. Do not throw them in the trash unopened. If anything, at least respond, refuse for cause, without commercial dishonor, return to sender. Do not just blatantly disregard the mail, because that's how they're getting you, through an administrative process of service, and you aren't rebutting the claims, and they're turning around and capitalizing on it and getting paid because you don't have a defense by the time you get to court, because the process has already been executed. Now it's just a matter of fulfilling the order and getting somebody to rubber stamp it, okay? It's funny because when you start to execute the process on the judges and the lawyers, though, it's extraordinarily funny to the lengths and the extent they will go to bend the procedure in their favor. Find CFO Duns & Bradstreet. Let's you search by name, the DNB.com, and it's important to find out who these people are. You have a third-party witness to every element of a claim, which is essentially a judgment. In Title V, that's what they are doing to you. It's not that the bank has any claim on your house. It is that they get you involved in a commercial process where you default on the process. That's how they establish the claim. Every time you receive something in the mail, it's a new offer. A new claim is being established. So, if you find yourself in court, something you can do is, Your Honor, I accept that condition on proof of claim that I do not have a paramount security interest in this property, or on proof of claim that this court doesn't operate under contract, or on proof of claim that you don't understand offer and acceptance, or on proof of claim that the court operates strictly off the offers and acceptance, or on proof of claim that I agree by contract to serve 5 years in prison. You see how this works, ladies and gentlemen? Put the onus of probandi back on them, do a conditional acceptance and accord and satisfaction. You know, you're offering to settle this matter, to handle it in an honorable way. It's completely irrespective of whether or not they're bringing true allegations against you. The fact of the matter is you're standing in honor by saying, yeah, I'll conditionally accept this allegation provided that they can prove their claim. I don't need to come into this court and plead to you when they have the onus of probandi on them. Why would anybody on God's green earth walk into a scenario and enter a damn plea when the plaintiff's the one bringing the damn claim? Excuse me, are you not a third party, disinterested party, non-biased individual set to hear this matter? I am. Wonderful. Why don't you start with the jackass that brought the claim? I'm not the one with the burden of proof. He is. If you got any questions, that should go to him. And I hope to God you don't plan on practicing law from the bench today. I catch you doing that crap, and it's on. But better yet, why not just appoint him executor from the beginning over the estate? And make sure that they know that you're the beneficiary. And if they cause you any harm, damage, injury, or loss because they're not bonded, because they're not doing things the right way, you're going to go ahead and need an itemized list of everything they own so you know what you can come after when they screw you over. Right? We want to know what they got. Anybody bringing a suit against you has to have something in the game in case they cause you harm, injury, damage, or loss. That's why they're supposed to bond the cases. But if they don't want to bond the cases, fine, so be it. I want to see an itemized list of everything you own. So in the event that you do cause me harm, injury, damage, and loss, I have an itemized list of everything that I'm going to own at the end of the day, that I'm going to put into a trust, that I'm going to ensure never gets stolen from my family if I end up in the nursing home. Okay? It's all about trust law, ladies and gentlemen. It's about contract law. It's about understanding there really is no law in this country or in the world, furthermore. And if there was law, let's look at the supreme law of the land. Thou shalt not murder. And yet we dress up men and women in little tinker toy freaking army suits every day and we murder thousands of people. We drop 27,000 bombs a day in other countries and nobody ever thinks about the moral ramifications of it. We raise our offspring not to murder, steal, lie, loot, and pander, and yet when they become a lawyer, we're so proud of them at graduation. Look at my proud little baby boy. He's a professional liar now. Everything I raised him not to be, but by golly, he's got a paper certificate that says he can do it. I'm so proud of little Tommy. I mean, what an asinine society. Absolutely insane. So, anyway, enough about my rant. Back to this. If you have a power of attorney over someone in prison, you can get them out by properly using a GSA 28 form, an affidavit of individual surety, a 90, a release of lien on real property, a 91, which is a release of personal property from escrow, a 24 bid bond, a 25 performance bond, and a 25A payment bond. Ladies and gentlemen, I'm providing you guys remedy. And I'm not going to lay it all out there for you. I'm not actually going to do the paperwork for you. This information doesn't belong in certain people's hands because they seek to do evil shit. And I'm not going to assist them in facilitating their evil doings on other people. I'm not going to help them enslave other people. So for you guys out there going, oh, I want you to help me do this paperwork. You have to understand, I interview people before I help them. I need to know their heart is in a good spot. I need to know that they're pure of heart and that they don't have ill will or bad intentions. I'm not going to sit here and teach people how to take advantage of others because this knowledge is just that. You could do one of two things with it. You could do the best in the world with it, or you can turn around and injure people with it. And I'm not going to have that way on my soul. So I've given you a remedy. Now it's up to you to go research it. Okay? And for the ones of you that are diligent and will persevere, it's because your heart is right and it's in the right place. I absolutely will not show you how to fill out those forms, even though I know how to fill them out. I'm not going to do it. Go do your research. I'm pointing it out to you exactly what needs to be done in order to get your loved ones out of prison who have been falsely accused and don't belong there. I'm talking about child support. I'm talking about, you know what breaks my heart is when I see a bank robber. The poor son of a gun is in a bank robbing worthless paper out of a bank and going to prison for the rest of his life for it. All for what? To survive? To put food on the table? And he's stealing worthless paper. It's worth nothing. It's worth nothing. And yet these people are willing to go to prison for it. Make a special appearance, make a letter rogatory, and every time I have done one of these, I have been successful. You have to read UCC 3-501 and 3-502. It tells you how to do a conditional acceptance upon proof of claim. You have to challenge their right. Most of these people are making presentments on behalf of someone else. They don't ever tell you their authority to do that, or where they get their authority to do that. When they do these loans, that's what they're doing on a mortgage loan. They are making a presentment on behalf of someone else. You can kill all these mortgages and on the administrative level. They should never be in court, ladies and gentlemen. If you're getting studied up and you're becoming learned, UCC 3-501 and 3-502 tells you exactly what you need to do. This should never be before court. Remember, court is had via the mail, ladies and gentlemen. What happens in the courtroom is nothing more than semantics and a silly soap opera, okay? Know this to be true. You know, they take it out of these loan applications. None of the applications have that disclaimer in it. That means there is no holder in due course. Because if you read UCC 3-302 of the UCC, a holder in due course takes it free of all claims and defenses that the payer could assert against any payee or assignee or transferee. That you don't take it free of that, they take it subject to your claims and defense. When you are dealing in securities, it is governed by Article 8. Not Article 3 of the UCC. What you call a note is a security, and it is a non-negotiable instrument. If you read the adjustable subprime mortgage, have an adjustable rate rider that goes with the note. The rider modifies the condition of payment and supplements and governs the promissory note. UCC 3-106D. It can't be a negotiable instrument if it is subject to or governed by extraneous documents outside of the promissory note. And they make it subject to the adjustable rate rider and the deed of trust. There are a dozen cases that say all mortgage notes are non-negotiable instruments. If they are non-negotiable, they are not governed by Article 3. They're governed by general contract law. Specifically, restatement of the law, second series under contract section 164, which has to do with misrepresentation, which means it's subject to rescission. If you read 226.23 of the TILA or Reg Z, Title 12 CFR in the appendix, there is a form H8 and H9. It is in the appendix. The lender has to give you the form to rescind. That's all in 226.23. It says that it doesn't apply to residential mortgage loans, but go down in section H, it says, at foreclosure, you have the right to rescind the loan transaction if two things occur. Listen up. Number one, there was no mortgage brokerage fee charged, and number two, you were not given notice of right to rescind. Number three, or you were not given appropriate form. The form is Appendix H8 form and H9. so you could rescind the transaction when it goes to foreclosure. They will tell you only have 72 hours. If they did not give you notice, the statute of limitations does not toll until they tell you. You have a right to rescind. You can do it at foreclosure. Another thing, you are not in a loan transaction. You are in an investment contract under UCC 4-102 under applicability. Says if an item is includable in Article 3, it's governed by Article 8. Article 8 governs Article 3 because you are dealing in securities, okay? All these notes are securities, not notes or negotiable instruments. Article 8 governs 3 and 4. What you have to do is you have to claim in recoupment or a claim under UCC 3-306 to the proceeds and a right to rescind the negotiation. And you have a promissory, a possessionary and property right in the proceeds of the investment contract. File the dang claim. If you read UCC 8-505 to UCC 8-508, it tells you how to file a claim. The claim is called the adverse claim. It is defined in UCC 8-102 and UCC 8-105. So read through that of Article 8. All these mortgage transactions are governed by Article 8 or Article 2, and you have never filed a counterclaim. That is why they file a 1099-A, because they say you abandoned your claim or recoupment, which is a counterclaim, and your possessionary right to the proceeds from the sale of the security under the investment contract to which you are undisclosed third party in the contract under the statute of frauds. If they are going to hold you liable under a contract which you are an undisclosed third party and it has not been subscribed to by you and you have not memorialized it, then you have a right to the proceeds. Go after the proceeds. It tells you how to do that. Nobody is doing that. Read the dead man statutes, which were codified under the probate law, Rule 601, under federal rules of evidence. It goes to competency to testify. They are incompetent to testify for a dead person. Who is a dead person? The corporation. They are dead because they are not real. What an attorney does is they testify on behalf of all these banks, and if you do not raise the objection, you waive the objection. You lose that right. Don't let these people stop you when you're trying to talk, saying, now's not the time to make that statement. Horsepucky. You make an affirmative statement, or you lose it. You lose it. I can't tell you how many times I've been in court and they've tried to say, now's not the time to talk. Bullshit. If I've got an objection, if it calls for speculation, assumed evidence not in facts, all this stuff that arises at a moment's notice, if you don't stand on it, you lose it. Okay? There is no, we'll get back to that in a minute. Something was said, it needs to be addressed. That is the first thing to do. I am before this court by special appearance without waiving any rights, remedies, or defense, statutory or procedural. I put the admonition at the top of my pleadings. That way you don't waive jurisdiction. Otherwise, you are going into a contract with these people. You contract then when they rule against you, even though they didn't have subject matter jurisdiction. You gave them that. You gave them jurisdiction, but not subject matter. But you have to raise it. Also, in personam, in order for the court to have jurisdiction, the plaintiff has to be there and the defendant. How many times you guys been to court and all you see is an empty seat with some butthead over there, a professional liar, alleging the state's bringing a claim against you? Well, they don't have in personam jurisdiction then, do they? Because you don't actually have a plaintiff facing you. And a state can't be an injured party because a state is nothing more than a name scribed on a piece of paper. It's facetiously ignorant. Unless you got out your lighter, went to the archives, and burned that piece of paper, you did no damage to the state. but you have to raise it. Also in personam, in order for the court to have jurisdiction, the plaintiff has to be there and the defendant. Both parties, real parties in interest that have standing under Article 3, Section 2. Standing is a threshold issue, and the court is supposed to address the sua sponte, and they are not doing it, ladies and gentlemen, so force that issue. They do not qualify under Section 86.2 and 862 and 852 of Title 26 as real estate investments trusts. So they're in possession of contraband. So what they are doing is billing you for tax that they owe. No one raises this issue because they don't understand it. That is why every mortgage is a tax issue. There are two issues, an investment contract and a tax. The reason a tax comes into play is because they never transferred the security. They kept the security. So that means all the investors that brought cash flow claims under the pooling and servicing agreement have got worthless paper, ladies and gentlemen. That means the trustee's in trouble, the bank's in trouble. We're looking at securities fraud, investment fraud, all kinds of different schemes these people are running amok on you, all while they're trying to foreclose. And they're guilty as guilty gets. That means there is a cloud on every title, and none of these notes were ever securitized. That means every B5 prospectus, S3 registration statement, and 8K current report are invalid. In 1951, they passed a law, Title 26, Section 2038 and 2514. It is called the Power of Appointment Act. The donor has total power. Every one of these mortgage loans transactions is a donor-donee relationship, which means it is a Class 5 gift and estate tax under 6002090 decoding manual. IRS means it is a Class 5 gift and estate tax. IRS processing manual of 2010. If you go in there and all 1096s, 1098s, 1040s, 1099s, all W-2s, W-4s are a Class 5 gift and estate tax. They have nothing to do with an income tax. 1040 forms, you don't report gifts and estate taxes on a 1040. That's for income. All Class 5 gift and estate taxes are on a 706 or a 709 form. Okay, these are IRS forms, ladies and gentlemen. I encourage you to go look at them. There are two types of taxes. Form 706 is a generation skipping tax, and 709 is a gift tax form. There are two types of taxes, generation skipping transfer tax, which is a 706, and a gift tax 709. If you go read publication 950, ladies and gentlemen, it's an IRS publication 950, you have a 3.5 million unified tax credit. That means if you know about accounting, corporations use that 3.5 million tax credits. They're using it as money. Okay, tax credits are money. They're value, ladies and gentlemen. And by Congress, you're allotted, I said it was 11.2. I stand corrected. It's 3.5 million tax credits a year. Corporations use tax credits as money. UCC 4-4.5, UCC 4-4.5 through, my notes are a little screwy here. UCC 5-104 defines the originator of the first fund transfer. When you read UCC 4-3-105 of the UCC, it tells you who the issuer is and the issue. Under subsection A, it defines what the issue is, and C defines what issuer is. The issuer is the drawer and the maker. If you sign the mortgage notes, you are the issuer by legal definition. Does that tell you anything? What did you sign? You endorsed the security. Well, don't you have a proprietary interest in the proceeds from the sale of the security? You bet you do. They made you a party to the investment contract. So why aren't you claiming it? This is why people are not winning in court. This is a UCC Article 8 102A1 adverse claim, a claim that a claimant has a property interest in a financial asset and that it is a violation of the rights of the claimant for another person to hold or deal with the financial assets. UCC 8-102 subsection 9, a financial asset is a security. You got a property interest in a financial asset. Isn't that what a UCC 3-306 says? Property interest? And when you go to the UCC 8-105, a person has notice of an adverse claim. If a person knows of the adverse claim, they know you have an adverse claim. They had notice of it at closing. Aren't they aware of facts sufficient to indicate that there is a significant probability that the adverse claim exists and deliberately avoid the information that would establish evidence of the adverse claim? Don't they have a duty imposed by statute or regulation to investigate whether an adverse claim exists? Don't they have knowledge that a financial asset or interest therein has been transferred? All this, 8, is found under UCC 8-105, then 8-505, tells you how to file the claim. You fund the whole damn thing. Well, they can't be a holder. A holder takes it free of all defense and claims. So they are not the holder in due course. What does UCC 3-305 say? Defense and claims and recoupment, that means counterclaim. Go look it up. UCC 3-305C, it says the obligor is not obliged to pay the instrument if the person seeking the enforcement, the instrument, does not have the right of the holder in due course. What does that tell you? If they're taking it subject to your claims and defense, then they are a holder in due course. Then are they the holder in due course? The answer is no. Doesn't that say you don't have to pay it? Go read UCC 8-505 and UCC 8-508 and the UCC. You have to find out who the broker or clearing corporation is, and you got to send a written communication. This might be a good time to go into that. I'm going into the UCC. Hang on. UCC 8-505 says the duty of securities intermediary with respect to payment and distribution. The securities intermediary shall take action to obtain a payment or a distribution made by the issuer of a financial asset. You know what I would do? I would find out who the title company, insurance company is, find out who the errors and omissions carrier is, and tell them that you want to file a claim. Tell them you want a release of lien and reconveyance on the property because of the E&O claim, errors and omissions. If they don't give you the release and reconveyance, the title company has the right in California under 29.41.7. A top gift and estate tax attorney, a donation of your property to the county. Your mortgage is a donation under Title 26 B11A4 subsection 2055. You deduct the entire amount. It's 100% tax liability. It should be reported as a donation. So, you're not getting your donation? Treat it as a donation. All monetary transactions are donations. There is no money. Title 26 A1B4 subsection 141, private debt instruments. Force them to pay the tax, do an OID. Do a margin call on them, 50% credit. That is why they want you to put a bond up. Read Title 26B11A3, subsection 2032E11. The court has to cover their capital transfer tax they haven't paid. They have to put a bond up, or release you. They are holding you for the funds. They are using your exclusion to keep you in bondage to cover their margins. Use a constructive trust along with the executor letter. Constructive trust is what a court of equity uses to give restitution and reimbursement to plaintiffs. Use a constructive trust when the person is in possession of money that they are not entitled to. Regards to executor letter, the office is vacant. As a donor, you have the Power of Appointment Act of 1951, and you can appoint yourself the executor. Put it in a letter under Title 26, 2038, and 2514. I am appointing myself the special occupant of the legal estate of the decedent by absolute estate. As the donor beneficiary of this constructive trust, I am appointing myself. I am claiming the office of special occupant of the legal estate. It's not a legal estate because there is no executor. And estate is when intestate is when a estate has no heir or beneficiary. That is why the judges are doing constructive trust and equity to give restitution and reimbursement to the plaintiff, which is the lender or servicing company. Because there is no heir or beneficiary. You are the heir or beneficiary. You are not stepping up to the plate, and that is why you are not winning in court. Just make them liable for the taxes. Taxable termination. I appoint myself the donor as the executor of the estate and making you the trustee by power of appointment of the Power of Appointment Act of 1951. What are they going to say to you? Send them a letter that under Title 26, 2038, and 2514 under the Power of Appointment Act of 1951, you're appointing them as the executor of the estate of the decedent, and that makes them liable for all the taxes on the estate. The executor has to pay the tax. You can appoint before you can do anything. You have to know what's going on, and there are regulations which are at 48 CFR codes of federal regulations. All this stuff is in these treaties. There's a lot of information in that. You need to sit down and read so you can understand what's going on before you do anything. This is why people don't win in court. If you don't redeem the bond, all this trial and presenting is a dog and pony show. Question. Don't use a bond, use a bid bond. If you look at the bid bond, it has the principal up there. Form 24. It's got the word principal up there. You're the principal. Who is the surety? The straw man is the surety, so you put the straw man name down as surety, and you put yourself as the beneficiary, or as the principal. Then you fill out a performance bond. The performance bond is a reinsurance for the bid bond. Put yourself down as the grantor or reinsurer. The performance bond is 274 or 274. You have three different bonds: bid bond, performance bond, and payment bond. The payment bond is the underwriter of the performance bond. You can do all three bonds. You can underwrite the performance bond and underwrite the bid bond with the performance bond. That's the reinsurance. They're doing it for you because nobody knows this stuff. You're the one that created all of this mess. If you have a case pending, what you should do is go take whatever district you're in, go find the district court and type in your case number, and it will tell you all about the bonds. Who's got your bonds? I'm going after my bonds. Question: are you the reinsurer on the payment bond? Also, well, you're acting as the underwriter to tell you what's going on with the banks. The banks are all tied with this. Every time you sign any money at all, a check is a promissory note. The banks made a derivative on it. The banks do not have any money at all. A check is a promissory note, and that they do what they do is endorse it on the back after you present it to for payment, and endorse it on the back without recourse. And then they sell it as a derivative. They monetize it. They monetize debt under the Monetary Control Act of 1980. The to monetize it and sell it internationally. If you have a check for 100, you will have 20 or 30 international corporations using that check. Is that why they never give you back the checks anymore? You got it. The question was for the audience. Why don't you get your canceled checks back anymore after you present for payment? The reason you don't get them is that they sell them as a promissory note. All personal checks are promissory notes, and the banks make derivatives out of them and sell them internationally. You're actually loaning money to the bank. You talk about screwed up. Now you know why they have proctologists. You're loaning the money to the bank, and the bank loans it to other people with derivatives into billions. How much are they making? Trillions of dollars. When it goes internationally, you're getting into 9 and 12-digit figures. I have court cases coming up. If it's already in default, is it necessarily fatal? You can cure the default. I use default judgment in some terms of dishonor. Jack is absolutely correct. When you go into dishonor, it looks like what they are doing is suing you civilly, a civil suit for a collection of a debt. And if you go into default judgment, if you have a claim, and I am talking a mandatory Rule 13. Rule 13 says that when a claim arises from the same transaction or occurrence, it's mandatory that you file a counterclaim. What is your counterclaim? Post-settlement and closure of the account under public policy. You're entitled to discharge of the debt because, number one, you're the principal and you're the holder in due course of the original account. I'm more than happy to give you my name if you can show that charging papers have been put into the court record. I have not seen any that show any charges exist. That's a negative avertment, ladies and gentlemen. What you want to do is settle the account. Go to full settlement and closure. You're running the account. You're the fiduciary trustee over the account. Tell them what to do. You're the principal and owner of the account. Tell them what to do. Tell them you want full settlement and closure of the account. You have to do this from the get-go. Here's the wording I use. I accept your charges for value and consideration. You have to use the words value and consideration. This is what I did. There's different forms that need to be used, and that's value and consideration. I accept your charge for value and consideration in return for post-settlement and closure of account. Put down your 9-digit social security number and put down the QSIP AutoTrice number. AutoTrice means Automated Tracking Identification System. I accept your charges for value and consideration in return for post-settlement and closure. Put your case number, an AutoTrice and QSIP account number, and then put your social security number after it. Then date it and endorse it. That comes after the AutoTrice and post-settlement. You say, please use my exemption for full settlement and closure of this account, as this account is prepaid and exempt from levy. Under Rule 8 of the FRCP, Federal Rules Civil Procedure, I accept the charges for value and consideration. In return, please use my exemption as principal for post-settlement and closure of case number and QSIP number and AutoTrice account number, social security number, as this account is prepaid and exempt from levy, and you would date it and endorse it. My opinion on that is that you are the fiduciary trustee and you're assuming the responsibility for the straw man as the authorized representative. You're the authorized representative for the straw man. My question is if you are used by the underneath the name put authorized rep, what that is stating is some other person other than the straw man signed that paper. Yes, so that doesn't make you liable. The other way of doing it is using real Christian signed that paper. Appellation